Welcome back, everyone, and today's courtroom story starts with a combination that almost guarantees chaos because we are about to watch a self-declared sovereign citizen mixed with full Karen-level confidence step into the courtroom and challenge the system. And if you have ever seen how either of these personalities behaves on their own, you can already imagine what happens when both attitudes exist in the same person standing in front of a judge, and the moment the hearing begins, you can feel the tension building, because a situation that starts like this almost never ends quietly, and you just know this courtroom is about to witness something unbelievable.
Your Honor?
Yes, sir.
Before you call the case you think I might be here on, I've had a chance to talk to Ms. Seeley. She was in the MIDC waiting room, and I explained the charges to Ms. Seeley. However, she would like to know under which jurisdiction I operate. I've explained that I'm a criminal defense attorney and I don't operate under any jurisdiction, so I don't think she's seeking the services of an attorney at this time, and the court may like to speak with her.
Thank you, Mr. Batar.
You're welcome, Judge.
These are 23HR0457 A, B, and C. These are Huron Township versus Bonita Seeley. Ms. Seeley, were you able to hear Mr. Batar just now?
First of all, are we on the record?
Yes, ma'am.
Okay, are we under penalty and perjury?
Are we on what, ma'am?
Under penalty and perjury, if you're willing to swear in.
I'm sorry, ma'am. I can
Everybody-
barely hear you.
I said, is everybody willing to swear in under penalty and perjury?
Ma'am, we're not taking testimony as of yet. Today is the day and time scheduled for the pre-hearing and adjourned arraignment pretrial in these matters.
It still has to be placed on a record. He still has to be put under penalty and perjury because he's swearing to an alleged crime against him and holding me accountable. So even though this is just a hearing, it still has to be put on notice for the public as well.
Well, here is the ironic part. This is a court of record, which means every word spoken becomes part of the permanent public record. So in a way, every time you speak, you are putting your own confusion on full display, especially when you start demanding things that make absolutely no legal sense, like insisting that your own lawyer must be sworn in under penalty of perjury, even though the lawyer is not a witness and is not testifying to anything. And then, to make it worse, the phrase itself is completely wrong, because the law says penalty of perjury, not penalty and perjury, which may sound like a small difference, but in a courtroom, details like that matter a lot, especially when someone has decided to represent themselves in a serious criminal case.
Ma'am, today is the day and time scheduled for the pre-hearing and the arraignment pretrial. Would you state your name for the record, please?
Bonita Seeley.
Ms. Seeley, Mr. Batar is the court-appointed attorney assigned to this courtroom for the day. He's indicated that you don't wish to engage his services. Is that correct?
No, let me explain my position. I asked him a simple question about jurisdiction. That's why this hearing has been re-adjourned for today, because the last hearing, none of the attorneys could answer the question in regards to what jurisdiction that we're operating under. So they want to proceed without addressing the jurisdiction, which is a violation of due process. So in order for him to be represent me on any public record, I have to understand what jurisdictions he's operating on.
Ms. Seeley, if you do not wish to use the court-appointed attorney, and you confirm as much to the court right now, Mr. Batar can go back, ma'am, Mr. Batar can go back and do other things that he needs to do this morning. Do you wish to use Mr. Batar's services, or do you wish to represent yourself this morning, or do you wish to retain counsel through some other mechanism?
Under what charge, under which jurisdiction, and then who's bringing the charges against me?
Ma'am, there were citations issued against you in Huron Township for limited access speeding 11 to 15 miles per hour over the posted speed limit. That's a civil infraction. There's count 2, no proof of insurance, and there is the misdemeanor of driving while license not valid or improper license. Do you wish to use the services of the MIDC attorney, or do you wish to represent yourself this morning, or do you wish to retain counsel?
Who are the parties bringing this claim against me? It's a simple question.
That question might sound simple, but the judge has already made the answer perfectly clear. The charges against you are being brought by the state of Michigan, and they are criminal charges, which means this situation carries the real possibility of jail time, and that is not the kind of situation where guessing your way through legal arguments usually ends well. The court has already explained who is bringing the charges and what is at stake, yet the confusion keeps going. And at this point, the judge is practically giving you another chance to reconsider, because when someone is facing the power of the state in a criminal case, having a lawyer is not just helpful, it can be the difference between understanding the process and walking straight into consequences you were not prepared for.
I answered your question, ma'am. I answered your question, ma'am. I answered your question, ma'am.
And could you re-answer it? Because I didn't hear it. Who's bringing the charges against me?
The citation that was issued to you was issued by an officer from Huron Township, Freddie Yono. It's the citation that was issued, is signed.
So it's Freddie.
It has his name and his ID number. Ma'am, my question to you is, do you wish to engage the services of the court-appointed attorney, or may I release him to go back to do some other work?
Wait a minute, I have questions before I can answer on. You're trying to get me to...
No, ma'am. No, ma'am.
Yes, it's a due process violation. Objection. Yes.
Miss Seeley, this is the third and last time I'm asking you. Will you be using Mr. Bittars to represent you this morning, or do you wish to retain your private attorney, or do you wish to represent yourself?
I need to understand what jurisdiction we're under.
Mr. Bittar, you may return to your breakout rooms to meet with other potential clients. Thank you.
Thank you, Your Honor.
Your Honor, if I
Ms.
may.
Seeley, do you intend to represent? I'm sorry, Ms. Foley Carter.
I just want we started this case back in July. Ms. Seeley attended her first pretrial. She demanded that the case be dismissed. I declined. I asked that the case be set for a bench trial. Ms. Seeley objected, and Magistrate Hinman advised her to file a motion stating her objection. Since then, she asked Judge Green for her oath of office and then didn't appear for the court dates before Judge Oakley. So this case has been going on for quite some time with no resolution.
Because I'm asking a question and it requires a rebuttal and it's being ignored. You cannot violate the due process. This is a hearing, and any questions that I have needs to be answered. You don't get to sit in the capacity of government and ignore the questions that the people have. Someone's bringing a claim against me, and my only question is, are we dealing in a commercial or a common law, also known as a record of law, court? That's simple. So are we in a common law court, yes or no?
No, this is not some imaginary common law setting. This is the 34th District Statutory Court of Michigan, a real court that handles both criminal and civil matters under state law, and repeating the same argument over and over is not going to change that reality. The truth is, you do not personally need to understand every detail of the court's jurisdiction, because that is exactly why people hire attorneys. Your lawyer is the one trained to understand the law and navigate the system, while your role is simply to listen, follow the process, and let the professional do the work. But instead of doing that, you keep interrupting and challenging things you clearly do not understand, when the smartest move right now would be to step back, stay quiet, and allow your attorney to handle the situation before it gets even worse.
Marianne, a in-person bench trial date in this matter, please.
Objection. Are we in a common law court, yes or no?
January 23rd.
Case dismissed.
At 11 o'clock.
Case dismissed. Case dismissed because you refuse to rebuttal to the question regarding jurisdiction. You cannot proceed without honoring the jurisdiction. You cannot be in the capacity of a... Yes.
The misdemeanor matter and the two civil infractions that are traveling with it that were issued on... that were issued on April 26, 2023 will be set for an in-person bench trial in courtroom number 1.
Objection. I will not be showing up. Objection. I will not be showing up. You refuse to answer the question of jurisdiction. You're trying to get me into the courtroom so you can take me against my will and lock me up in a cage like an animal. Objection.
At this point, it feels less like someone standing up for their rights and more like someone walking straight into trouble, because if you truly care about your freedom, then the smartest thing you can do is take the court seriously and actually show up for your next hearing. The reality is very simple. When a court orders you to appear and you ignore that order, the judge has the power to issue a warrant, and once that happens, your situation can go from a simple court appearance to being taken into custody very quickly. And that is when people suddenly realize that the courtroom was the easy part, because once you fail to appear, the system treats it as defiance, and the consequences can mean sitting behind bars while the case moves forward without you.
You do not have jurisdiction over me. You do not have judicial authority in North America. You are working for a municipality called the state of Michigan. You have no jurisdiction. You are an attorney. You work for a corporation. You are in a municipal capacity. You have no authority. You call yourself government. Your position is a public servant.
Miss
I am the objection.
Miss Seeley,
no, you cannot proceed as an attorney. Objection. I will not be showing up in court. I will appeal this matter. Objection.
There is no question pending to you, ma'am. This court will be muting you at this time because this court, the court has muted Ms. Seeley as her responses are not responsive to the matter that is before the court. This matter is being scheduled for trial. If Ms. Seeley wishes to absent herself from that trial, that is her absolute right. That trial date is January 23rd
I will not be showing up.
That concludes this matter.
And even as the hearing is wrapping up, she still tries to squeeze in one final objection, almost like she cannot resist getting the last word in. But the reality of the situation is already set in motion. The judge has made the expectations clear, and the consequences are not hard to predict after watching how everything played out. And as it turns out, the outcome followed the exact path many people expected, because after waiting a few weeks to see what would happen next, it became clear that she never showed up for her next court date, which means the court will almost certainly issue a bench warrant, and sooner or later, she will be brought back before the judge to face the situation again, proving once more that ignoring the court never makes the problem disappear. It only delays the moment when everything finally catches up.